no amendments of the proper kind would ever be obtained by the people if the government should become oppressive. George Mason. Guest essayist Gary Porter. Prior to achieving statehood in March 1791, the Republic of Vermont placed a provision in their 1786 state constitution. Every 7 years, the people would elect a 13-person council of censors, who would examine whether the Constitution has been preserved inviolate in every part during the last septenary, including the year of their service, and whether the legislative and executive branches of government have performed their duty as guardians of the people, or assumed to themselves, or exercised other or greater powers than they are entitled to by the Constitution. They are also to inquire whether the public taxes have been justly laid and collected in all parts of this Commonwealth, in what manner the public moneys have been disposed of, and whether the laws have been duly executed. This council would recommend to the legislature the repealing such laws as appear to them to have been enacted contrary to the principles of the Constitution. These powers they shall continue to have for and during the space of 1 year, from the day of their election, and no longer. The said council of censors shall also have the power to call a convention, to meet within 2 years after their sitting, if there appears to them an absolute necessity of amending any article of this Constitution which may be defective, explaining such as may be thought not clearly expressed, and of adding such as are necessary for the preservation of the rights and happiness of the people. But the articles to be amended, and the amendments proposed, and such articles as are proposed to be added or abolished, shall be promulgated at least 6 months before the day appointed for the election of such convention, for the previous consideration of the people, that they may have an opportunity of instructing their delegates on the subject. Laying on land claimed by both New Hampshire, New York, and, at times, Canada, Vermont finally became an independent republic on January 15, 1777. It called itself the state of Vermont, but failed to receive recognition by any country until admitted to the Union on March 4, 1791. Because of its independency, Vermont was not invited to the Constitutional Convention in 1787. If it had been invited, would these ideas of constitutional review and revision have made it into the United States Constitution? If the U.S. Constitution had contained such a provision, what sort of amendments might have been ratified over these 235 years? And over those years, would the Constitutional Council of Censors find repeatedly that the Constitution had not been preserved inviolate in every part? Amendment under the Articles of Confederation. One of the chief defects of the Articles of Confederation found in Article 13 reads in part, "Nor shall any alteration at any time hereafter be made in any of these articles, unless such alteration be agreed to in a Congress of the United States, and be afterwards confirmed by the legislatures of every state." This requirement for unanimity among the states meant that the articles would never be amended or otherwise improved. In his Vices of the Political System of the United States, James Madison's homework assignment to himself, he fails to mention this flaw among the 12 vices he identifies. It could be that much of the blame for America's moving to a new constitution is due to this one defect. At the Constitutional Convention, Charles Pinckney said, "It is to this unanimous consent provision of the Articles the depressed situation of the Union is undoubtedly owing. Had the measures recommended by Congress and assented to, some of them by 11 and others by 12 of the states, been carried into execution, how different would have been the complexion of public affairs? To this weak, this absurd part of the government, may all our distresses be fairly attributed." In 1781, a proposal was made to amend the Articles of Confederation to give Congress the power to set an impost on goods. Rhode Island refused to approve the measure. As described in the notes of Delegate James Madison, the small district of Rhode Island put a negative upon the collective wisdom of the continent. Just as Rhode Island's veto prevented the adoption of an impost in 1781, New York would be the sole state to obstruct a second impost attempt 2 years later. Early in 1785, a congressional committee recommended amending the Articles of Confederation to give Congress power over commerce. Congress sent the proposed amendment to the state legislatures. Only a few states responded. Later that year, in a letter to James Warren, George Washington wrote, "In a word, the Confederation appears to me to be little more than a shadow without the substance. Indeed, it is one of the most extraordinary things that we should confederate for national purposes, and yet be afraid to give the rulers of that nation sufficient powers to order and direct the affairs of the same." In 1786, Charles Pinckney proposed a revision of the Articles. A committee debated the proposal and recommended granting Congress power over both foreign and domestic commerce, and empowering Congress to collect money owed by the states. By now, convinced that at least one state would disagree, Congress never sent the measure to the states. Given this history, it appeared to the Constitutional Convention delegates that something less than unanimity was required to amend the new Constitution they had drafted. Amendment at the Constitutional Convention. Item 17 of the Virginia Plan, introduced in the Grand Convention on May 29, 1787, stated, "Resolved, that provision ought to be made for the amendment of the Articles of Union, whensoever it shall seem necessary." There were many provisions of the Virginia Plan to discuss and debate. The delegates did not discuss a process of amendment until a month before the end of the convention. The U.S. Constitution Analysis and Interpretation website provides this account of the debates over what became Article 5 of the new United States Constitution. Alexander Hamilton suggested that Congress, acting on its own initiative, should have the power to call a convention to propose amendments. In his view, Congress would perceive the need for amendments before the states. Roger Sherman took Hamilton's proposal a step further, moving that Congress itself be authorized to propose amendments that would become part of the Constitution upon ratification by all of the states. James Wilson moved to modify Sherman's proposal to require 3/4 of the states for ratification of an amendment. James Madison offered substitute language that permitted 2/3 of both houses of Congress to propose amendments, and required Congress to propose an amendment after 2/3 of the states had suggested one. This language passed unanimously. But on September 15, 1787, 2 days before the convention adjourned for the last time, Article 5 of the draft Constitution was again discussed. To that point, the approved wording gave all power to Congress to officially propose amendments, although the states could suggest them. Virginia's George Mason rose and cautioned that no amendments of the proper kind would ever be obtained by the people if the government should become oppressive, as Madison wrote in his notes, as he verily believed would be the case. Governor Morris and Elbridge Gerry then moved to require a convention on application of 2/3 of the states, and the motion passed nem. con. unanimously. And this provided the alternate method of proposing constitutional amendments, a convention of states. But notice the rationale for this alternate method of amendment. Should Congress become oppressive? The process of amendment placed in Article 5 was further debated in the state ratifying conventions, the records of Massachusetts, North Carolina, and Virginia, particularly recording the concerns of delegates. Some convention delegates, like Virginia's Edmund Randolph, who refused to sign the Constitution, even called for an amending convention to be immediately convened to fix the deficiencies in the Constitution before they went into operation, which would make them harder to correct. Madison thought the idea dangerous. Randolph's suggestion never gained momentum, and the Constitution was ratified by Virginia on June 26, 1788, 4 days after New Hampshire's ratification sealed the deal, because it was the 9th state to ratify, the number of states required by the new Constitution. Less than a year later, the new national government went into operation, amending the Constitution correctly. Article 5 of the United States Constitution contains 2 methods of proposing amendments and 2 methods of ratifying amendments. Congress, with 2/3 vote of both chambers, can propose an amendment for ratification by the states, and the states themselves, in a convention called for that purpose, can propose amendments for ratification. Over America's history, all 27 current amendments have been proposed by Congress, none by a convention of the states. Ratification of a proposed amendment can also take 2 forms: ratification by 3/4 of the several state legislatures, or ratification by 3/4 of state conventions held for that purpose. Congress may propose either method. Over America's history, the later method of ratification has been used only once, to ratify the 21st Amendment. As many as 5,000 amendments have been proposed in Congress since the Constitution went into effect in 1789, and only 27 survived the high hurdle of committee discussions and votes, followed by supermajority floor votes in both chambers. Gary Porter is Executive Director of the Constitution Leadership Initiative.